Danny Schaefer versus City of Kissimmee.
May it please the court, Todd Sanders for the appellant, Danny Schaefer. With the court's permission, I would like to reserve 3 minutes for rebuttal. The salient facts in this case, Your Honors, pretty much undisputed. This was a claim brought under the Heart-Lung Bill, which is codified at Section 112.18 at SEC. The claimant was a firefighter EMT. On January 2nd of 2005, he injured his knee, and was 2 days later, his employer sent him to the Madero Clinic to get his knee checked. While he was there, they, as per usual, took his blood pressure and other vital signs and asked him, "How long have you had hypertension?" And he said, "Well, I didn't know I had hypertension." He testified at trial that he was told at that time that his blood pressure reading on that day was 160/100. And he was advised by the person treating him or examining him at the clinic to go see a doctor regarding his hypertension. He reported this to the employer, both to his lieutenant and also to the city's risk manager. And he was told to go see his own private doctor. He was unable to get in to see his private doctor until January 21st of 2005. Prior to that, experiencing symptoms that he now knew were related to his hypertension, he returned to that Madero Clinic on January 18 of 2005. At that time, the Madero Clinic completed a report indicating that he had hypertension. It said specifically hypertension per Heart-Lung Bill, work-related per Heart-Lung Bill. Unfortunately, again, they didn't write down the actual blood pressure reading. They also indicated work status to be determined, but paradoxically also checked off full duty. So there's a little bit of an ambiguity in that particular form. The claimant was planning on retiring, and this is something that the city knew. The claimant was planning on retiring at the end of March, somewhere between the end of March, middle of April, per to the DROP program. It's a special retirement program for employees in the claimant's field. He was not sent to see a doctor by the employer until after his retirement. We believe that this case has some very serious policy implications for Section 112.18 claims. Basically, what happened here was the city had a firefighter where the city was basically tried to avoid having to provide benefits to a firefighter who was set to retire soon after an accident date, simply by delaying any action on the claim until after he retired, and then say he was not disabled because no authorized doctor took him out of work. And so therefore he failed to satisfy the disablement requirement of Section 112. That's all they had to do. Okay, we're just going to delay. We're not going to send you to a doctor until after you retire, at which point, well, the doctor can't take you out of work because you're already out of work. Okay? Here the city was notified that the claimant was diagnosed with hypertension on at least 2 different occasions. First, on January 4, 2005, when the claimant reported to his employer that he had just been diagnosed with hypertension, and then when they received the report from Madero Clinic on or about January 18, 2005. They wasted no time, however, in filing an initial denial on February 2, 2005.
Well, even if the city delayed, and if evidence was presented that the hypertension was resulting in a disability from a physician.
They didn't even send him to a doctor to determine whether or not.
I understand, but I'm not sure that I buy off in your argument that the retirement means anything, per se, or that delay means anything. Because you say that they delayed, so therefore he retired, so he couldn't demonstrate disability, but he could have demonstrated disability as a result if a doctor had said, you know, he can no longer work as a firefighter as a result of his hypertension. And isn't that the real issue here, whether we have competent evidence that his hypertension resulted in a disability?
Yes, sir. I'm glad you asked that, because basically what you have here is one of the reasons that the judge found that there's no disability is because no authorized doctor ever took him out of work. Well, by the time they sent him to an authorized doctor, it became a moot point. There was no work to take him out of because he was already retired.
Did any doctor testify that his disability precluded him, or the hypertension precluded him from acting as a firefighter?
Dr. Kakar, who was the cardiologist that the employer finally sent the claimant to see after he was retired, testified that if I had a patient who had a blood pressure level of 160 over 100, I would place him on medication and wait about 24 hours to see if that controlled his medication, and then he would be out of work for that time. We believe that under this court's decision in the city of Mary Esther versus McCarter, that that's sufficient for disability. It's an incapacitation. And disability doesn't mean, as this court ruled, it doesn't mean that you didn't get paid for the period, and it doesn't mean the same thing as not working. It just means you're not able to perform your full duties or functions as a firefighter or a law enforcement officer. And on that day, when he had that blood pressure level, he was incapacitated for purposes of the statute. I would note that 112.18 does not define disability, but this court has defined disability both through its Sledge opinion and through the McCarter opinion.
The statute defines disability, does it not?
I'm sorry, I can't hear you.
The statute defines disability. That is, the workers' compensation statute defines disability, meaning a loss of wage earning capacity.
Yes, that is one definition. However, also in McCarter, City of Mary Esther versus McCarter, it's incapacity. It's not just the wage earning. It's the incapacity to fulfill your duties as a firefighter.
At the prior wage, the capacity that one previously displayed. I guess I'm having some difficulty also finding where is the evidence, the medical evidence or otherwise, of that the claimant here was suffered any loss of total or partial disability as required by the statute.
Well, his disability was when he had the blood pressure level that the doctor testified was too high for him to go to work, that he would wait 24 hours after giving medication to see if he could return to work. Keeping in mind that this was not this claimant is not a claimant with a desk job. This is someone who has firefighting and rescue responsibilities. As I mentioned in my brief,
Dr. Kakar testify that he had no documentation of any blood pressure reading of
that's correct, Your Honor.
160 over 100?
However, the claimant's testimony represents the only evidence as to what his blood pressure level was on the day that he went to that clinic. The claimant should not be penalized because the clinic...
Was the JCC required to accept that testimony?
I'm sorry?
Was the JCC required to accept the claimant's testimony?
Yes, because it was uncontroverted. They never brought up any evidence to say, no, it wasn't 160 over 100. They never brought in anyone from Madero Clinic to say it was something else. The judge also never found that the claimant was not credible, which he was required to do. If he didn't believe the claimant, for whatever reason, he had to say why. He did not find that the claimant was not credible. He just said that there's no evidence of any disability as a result of the blood pressure, or there's no evidence of what the blood pressure level was. So here what happens is you're penalizing the claimant because the doctors at the clinic failed to write down on the form what the blood pressure level was. Or if there were any records to that effect, they lost them because both sides requested the records, and there are no records other than that one page that is in the record, and that shows that that's from January 18, indicating that his blood pressure was still serious enough where they placed him on medication that the city paid for, knowing that this guy had a doctor's appointment a few days later with his regular doctor. I'm not saying the city knew that, but presumably Madero knew that he had a doctor's appointment coming up, but they still gave him medication even though they had told him to go see his own private doctor or see a doctor, and the city said go see your own private doctor. But what we're missing here, though, are policy implications of a situation where you can have a claimant where the city knows that this guy is getting ready to retire. He files this claim. They don't tell him what his rights are under 112. They don't tell him he can get an IME. They don't tell him what he needs to do. They just stall. They stalled for about a month or two here, waited for the guy to retire, then sent him to a doctor, and then denied the claim after within 120 days after filing that letter. So the policy implications here are very serious. The cities all around the state are going to be looking at this case to see what can we get away with. We have We have firefighters who maybe have heart claims or lung claims or hypertension claims. They're nearing retirement. If all we got to do is stall and wait for 1, 2, 3, or 4 months before we send him to a doctor, we can avoid all kinds of liability for his condition. And, we believe that the 44009 statute does not apply to 112 cases for the reasons that are submitted in our brief. We believe here that the city has unclean hands. They knew exactly what they were doing. They had a claimant who had a hypertension claim. They had an obligation to at least get him checked out by a doctor on their dime, and they didn't do it until after he retired. And so they basically set him up. And then they send him this letter saying, okay, well, we're going to look at your claim. We're going to send you to a doctor. He never had a chance. He never had a chance to perfect his claim. And it would be, I think, a very bad precedent to set to allow cities to get away with this kind of behavior. Basically, the statewide disability, that one part of Section 112, disablement, that's that one thing that a lot of my experience, that a lot of these governmental employers are hanging on. They're saying, oh, you weren't disabled as a result of it. We're sending you all these tests and everything, and you're out of work as a result of the test, but you weren't disabled. You weren't incapacitated. And we feel that's the important point. It's incapacitated. And it only has to be temporary. It could be a matter of hours that, you weren't able to perform your duties as a firefighter. And that was the case here. And again, the claimant shouldn't be penalized because Madero failed to write down what the blood pressure was. But he testified, it was uncontroverted, it was never found to be not credible as to what his blood pressure was. And when asked about that blood pressure, the city's own doctor said that, yeah, I would take him out of work for 24 hours, to wait to see if the medication brought his blood pressure down to an acceptable level. And in addition, the city's own doctor's Madero wrote down that this is covered by 112.18. This is a heart-lung case. Hypertension is work-related. And so the only dispute here, as Your Honor mentioned, is whether or not he was incapacitated for any amount of time, and he clearly was, based on the uncontroverted testimony. That's all I have, Your Honor.
Thank you very much.
May it please the Court. My name is Barbara Egan. I'm with Broussard, Cullen, Gaylor, and Egan in Orlando, and I represent the appellees here, the City of Kissimmee and its servicing agent. This case, Your Honors, is not a case, as the claimant contends, about a city with unclean hands. This is a case about where the appellant simply did not submit proof necessary to meet his burden below to establish disablement. The date of accident in this case was claimed to be January 4th, 2006. And many times an IME evaluation or the assigned doctor's evaluation occurs after the fact. But in this case, the issue was that no doctor, neither the treating physician, the approved treating physician, nor the private physician, nor the initial clinic found any disablement related to this hypertension. The facts upon which claimant is basing his argument are purely subjective and speculative, and that is not sufficient evidence to support a finding of disablement. If we examine the record facts, they reveal a substantial basis for the judge of compensation's claims determination that no disability existed. When the claimant first presented with the knee injury to the employer's clinic, he was advised by a physician's assistant, this record shows, that he had a high blood pressure reading. The claimant himself, in his argument today, is asserting that that was a 160 over 100 blood pressure reading and that that's uncontroverted. Well, Your Honors, the record shows that this claimant also had testified to Dr. Chappell, not testified to Dr. Chappell, but presented to Dr. Chappell in one of his visits that the reading had been 156 over 92. The suggestion that Dr. Kakar made concerning a reading of 160/100 was based on a purely speculative hypothetical. In other words, if someone presents to you with symptoms that could be associated with high blood pressure, and they have a reading of 160/100, and you need to give them medication, Dr. Kakar said, I would wait because of that level for the medications to bring it down for 24 hours. But that is if there were symptoms involved that I related to the hypertension. Dr. Kakar also testified that you have to have an extremely high pressure, 240/160, I believe is the figure that he mentioned, before you really start to experience a physical sequela. That the levels that he was experiencing would not cause any type of disability or incapacity. In fact, Dr. Kakar, when discussing the range in the 150/92 range, which is what claimant had testified to Dr. Chappell, had said that would be something I would not be concerned about, even to return to full duty for a firefighter. Now, bear in mind that during this period, this claimant's job duties were, number one, for a period till January 17th, his job duties were off work, and number two, following that, it was light or modified duty, which according to claimant's testimony involved some filing from home and those types of situations. So there's absolutely nothing in this record that would support any physician finding that there was any type of incapacity based upon his condition. We also submit, Your Honors, that the workers' compensation law is quite clear that for its judge of compensation claim to find a disability, there must be objective medical evidence. And the argument that claimant suggests that 440.09 would not apply has no legal foundation. We submit that the slippery slope here, or the policy issues that would be involved, would be to permit a claimant to now provide self-diagnosis that would meet the definition of disability, would really turn our compensation law on its ear. We further submit, Your Honor, that a headache or being out of work for, he doesn't even say that he missed work for a day or whatever, he's just complaining about some headaches, that would not meet the definition of incapacity or disability for the purposes of any cases that have discussed that issue, including the Sledge case, which I believe came out in the 1990s. In that case, a claimant was diagnosed with a cardiac problem and actually spent time in the hospital for testing, deep shock treatment to try to resolve the condition. And the Sledge court did not classify that hospitalization as the event of incapacitation. In 2005, when the McWhorter case came out, that claimant was hospitalized and also experienced a period of recovery, and that set of circumstances could be classified by the court as a time of incapacity. In this case, we purely have a claimant suggesting that he should be found to be disabled because he decided that his symptoms were related to his blood pressure and made the decision that he was going to be taken out of work. Please understand that had Dr. Kakar, it didn't matter to us that claimant had already been retired. The city of Kissimmee was not trying to pull some underhanded scheme in getting this evaluation. It often takes a while to get these types of evaluations, and the situation would have been far different. It wouldn't have mattered if he retired, if Dr. Kakar had said, yes, what this gentleman has been experiencing and what these records show would have kept him out of work for a period of time, for a period of recovery. And I'm not saying 24 hours would have been enough, but the situation would have been entirely different. And upon these arguments today and our arguments in our brief, we would request that this court affirm the judge of compensation claims below. The decision is supported by competent evidence within the record. Thank you very much.
Any response?
would first like to remind the court of the very strong public policy that is behind Section 112.18 as enunciated in the City of Temple Terrace versus Bailey, as well as the landmark Codwell opinion. Here, if there's any conflict in the evidence regarding that blood pressure level or whether or not Madero meant to take him out of work when they indicated work status to be determined / full duty, should be resolved per Codwell in favor of the claimant to show incapacity or disability. Perhaps under a new accident date, because that form does indicate an accident date of January 18, 2005, although they had already seen him and diagnosed him with hypertension on January 4 of 2005. And as the court is well aware, in occupational disease cases, you can have multiple accident dates. It's each time you're disabled or incapacitated is a new, potentially new date of accident. Also, the claimant here testified to feeling fatigued during that period of time after he was first prescribed the Topol by the employer's own doctor at Madero, and the time he saw his own private physician, who did testify that Topol is a beta blocker, and beta blockers can indeed cause fatigue. This court has ruled in two cases, Jackson v. Dade County School Board and Morton Plant Hospital v. Kraft, that lay testimony, including testimony as to subjective feelings of pain, sequence of events, and also, quote, actual ability or inability to perform work, end quote, are within the purview of a claimant. Now, they do have to be corroborated in some way by medical evidence, i.e., you can't just say, oh, you know, I have hypertension and I have these symptoms. Here, there's no dispute that the claimant was diagnosed with hypertension. There's also no dispute that at least some of these symptoms are something that a person with uncontrolled blood pressure can experience. The claimant testified that he was feeling these very symptoms for months prior to the time he was diagnosed with the hypertension, and took himself out of work because he was feeling fatigued or dizzy and didn't think it was safe for him to be working, and it certainly wasn't safe for the potential victims that he would have been rescuing or treating. And it just fortuitously, he found out that he has hypertension, and unfortunately didn't find out about it until just before he retired, but it was diagnosed. And again, by dragging itself and by delaying providing at least rudimentary medical care or initial medical care, the city is seeking to avoid all liability because nobody took him out of work. The statute doesn't require that a doctor take a claimant out of work to establish incapacity. That in finding that, we feel that the JCC was legislating from the bench. In addition, even in City of Temple Terrace v. Bailey, to show you how strong public policy is behind this statute, there the claimant had an undisputed congenital condition, heart condition, but this court, my time is up. This court remanded that case to the JCC to find out whether or not the claimant's work was exacerbating that admittedly congenital condition. Thank you.
Thank you very much.